Joining me throughout the hour tonight to help break down today's events in court is my all-star team of legal experts. In Atlanta, trial lawyer and former National Bar Association President C.K. Hoffler. In San Francisco, veteran prosecutor and BNC's legal contributor Paul Henderson. And in Orlando, criminal defense attorney and president of the National Trial Lawyers Association, Mark O'Mara. Thank you all for being here tonight. All right, let's start with the defense's closing and work backwards. Lots of interesting arguments were made by the defense's lead attorney, Deborah O'Canic. He said nothing R. Kelly did was out of the ordinary, that as an international superstar, he was a sex symbol, a playboy who enjoyed kinky sex between consenting adults, which isn't a crime. He asked the jury to set aside any judgments about the types of relationships Kelly had and understand that these women were not only consenting adults, but bought into the lifestyle. CK, to you first. Can the defense simplify this case that easily?
Absolutely not. I quite frankly found that to be a ridiculous argument. For sure, R. Kelly is a superstar. For sure, there are a lot of consenting adults. There were a lot of people who probably were groupies that did partake in a lot of activities with R. Kelly. But to oversimplify 9 witnesses that speak of what I believe, if the jury believes it, really heinous activities, acts of sexual oppression against men and women, to overly simplify that when they actually heard live his voice and some of the things that he did to some of these victims, I think is a very risky move. And I don't think that you can oversimplify that case in that way. I think, frankly, it was a bad move for them to make in closing. That, and also equating R. Kelly to Dr. Martin Luther King. That was actually jaw-dropping to me.
We're going to get to that.
Oh, okay. I'm sorry.
We're going to definitely get to that. No. No, I'm definitely going to get to that. Mark, the defense argued that the government was trying to, quote, criminalize legal activity like kinky sex or sex between people of different ages, but underage girls can't consent. Could the prosecution have objected to that statement as a mischaracterization of the law, or the judge intervene at that point?
So, yes, the answer is if they misstate the law, then of course it is an objectionable argument. But remember, the jury is told it's just argument. It's the attorneys trying to give you their best perspective. Generally speaking, it's not a good idea to object during closing argument. You almost may give it more focus by doing so. But, you know, remember with a case like this, as was just said, you know, we know as lawyers, argue the facts when you have them, argue the law when you have it, and just argue if you don't have either. And I think what the defense was doing was trying to get so close to the edge, stay away from criminality, but say, look, kinky sex, doing this, daddy is not, you know, a abuse, and saying all of this is close. It's close to the edge, but it's not criminal, because they cannot deny all of the evidence that was presented by those witnesses. All they can say is, sure, that's close. Yes, it's close. Yes, it's kinky sex. No, there was nobody calling for the cops when they had their cell phone locked in some closet somewhere. Get so close to the edge where they can still say kinky behavior, but not criminal. So in that sense, having to accept the facts as they are now before the jury, you almost have to give the defense a little bit of credit of going, you have to acknowledge what you know the jury believes happened, but maybe it's not a crime. And I think that's where Canick was going with his arguments.
The defense then started to attack the credibility of Kelly's accusers, describing them as opportunists, liars, and obsessive fans. Paul, that's a common defense strategy, but the sheer number of accusers, 11 total, doesn't that make it hard for the jury to believe that all of them were being untruthful?
It does, and to Mark's point that he was just talking about, in terms of the mischaracterizing their testimony and their evidence, I feel like I try to give leeway in closing argument, but I would have objected. I would have interrupted, and I would have said that this crossed the line as the defense attorney characterized the behavior as not criminal. Now, that's just wrong. We're here in this courtroom because it is criminal. I would have objected, and I would have, if for no other reason, to stand up for those victims who deserve to be heard, for their voices that deserve to be believed, and for those jurors that were paying attention and believed, even if they just believed a few of them, if they believe any of them, I feel like that's the role of prosecutors to stand up for the victims and the witnesses that are testifying in a case like this. And remember, there are 11 witnesses, and of those 11 witnesses that testified as victims, not the witnesses, but the victims, 6 of them were underage at the time that they were involved with R. Kelly, which is the definition, as we've talked about before, of statutory rape. For that reason alone, I would have been more vociferous about objecting and making it clear to the jury that someone believes those men and women that were testifying. Someone believes that a crime has been committed, and I want you to believe that as well, and you're going to hear me be adamant and defensive about it when it gets mischaracterized on purpose as an adoptive admission from defense counsel in a case like this.
All right, CK, the defense invoked Dr. King and the civil rights movement in his closing, suggesting that the jury was facing a similar fight, asking them to be courageous and fair, and that by being so, that they would clear Kelly of all charges against him. Was this a stretch, and was this inappropriate?
I think it was a stretch, and I think it was terribly inappropriate, especially given where we are in this country now. I was actually disgusted by the mere comparison of R. Kelly in this case. Even if you assume he's innocent, the allegations in this case to compare him to Dr. King was a very, very bad move. And if they wanted to paint a path for the jury to walk down and convict him, they opened up the door and they laid that path right in front of the jury. That's how I saw it. Because if there were any people that were on the fence and really felt that some of the witnesses lacked credibility, by drawing that comparison with just the right jurors, you could have people or jurors that would really take a stand because they would be so offended by that comparison. I'm not sure why they took that move, why they took that risk, because that was a horrible risk in my impression.
I want to get all of your thoughts on that, Mark.
Wow. I looked at it, and at first I heard it before I actually read the transcript, and I said, well, maybe he made some offhand reference. And then I actually read what he said, and I remember, because I've had the honor and the pleasure of knowing Martin Luther King III and having served on a couple panels with him and gotten to know him just a little bit. And I just remember thinking and texting him and going, I'm just sorry that someone, anyone, would drag in your dad's name into this case and suggested, and again, even if he's innocent, as RK just said, even if he's innocent, the idea of dragging those two polar opposites together, somebody charged with child sexual abuse and Martin Luther King Jr., I didn't, it was disgusting, and I don't know what he was trying to do. Who was he talking to when he wanted someone to think R. Kelly and MLK Jr. are sort of fighting the same fight right now? So where was he going with that besides, I don't know, maybe making a name for himself when the case is over?
A bad one at that. Paul, your thought?
Okay, so I felt very strongly. My immediate reaction when hearing it was, ma'am, please take several seats. If you are even raising the specter of Martin Luther King with R. Kelly, are you freaking kidding me? In this courtroom, while we're talking about the herpes and sexual behavior and statutory rape and kidnapping and aggressive behavior and misuse of celebrity, and you dare to bring up Martin Luther King, sit down. But I think maybe that was part of the point, because I was so irritated by it and frustrated by it. I can't imagine that other people weren't as well, including viewers in America, even though it's not taped in video so we can watch the commentary live. I believe that had to be a distraction and a red herring. And I think it's one of the things that in a case like this is where defense gets backed into a corner where they don't get to argue a lot of facts. They don't get to argue a lot of challenges to the incidents that took place. They're left to bolster their defense by arguing and throwing anything out there that could be a distraction to the jury. I believe this is one of those distractions. that gets an entire audience thinking about Martin Luther King as R. Kelly, what the heck does that mean? And if they're thinking about any other thing other than the actual facts and connecting it to the elements that the prosecution has to prove, then that's a win. But it was so ridiculous and offensive is the issue. It was offensive to an audience. I believe it was probably offensive to several of the jurors as well, that even if they weren't familiar or fans of R. Kelly, they certainly didn't equate his behavior to anything in the sphere of Martin Luther King. And so, if anything, it was a distraction that may have served the defense a moment where they weren't thinking about the facts or the charges. But that's all it was. And it may have turned many of them, as it turned me, against the defense for daring to present it in that way. I was offended.
Yeah, I definitely think that it hurt their credibility. All right, we've got to take a quick break, but when we return, a breakdown of the prosecution's closing arguments with my panel of legal experts as we look ahead to deliberations. Stay tuned. In the R. Kelly trial rested Wednesday afternoon, so there was a chance the jury could have been deliberating by now. Instead, the prosecution's closing arguments took 6 hours, which they wrapped this morning. Still with me, C.K. Hoffler, Paul Henderson, and Mark O'Mara. All right, let's get into the government side of the case. Mark, let's talk about the prosecution's 6-hour long closing arguments. They revisited testimony given over 6 weeks related to the 14 underlying acts Kelly is accused of committing under the racketeering charge. Yes, the prosecution, they have the burden of proof, and this would be the last time they would address the jury. But was this information overload and a risk of losing the jury?
6 hours is an enormous amount of time for anyone to pay attention to anyone. The only ones who are good at that is lawyers when they're listening to their own closing arguments. When you have somebody else out there 6 hours trying to listen, it's difficult. Now, you mentioned it's a 6-week trial, so if you look at it that they spent an hour per week, sort of, it doesn't seem like much. But I thought they did a good job. It was methodical. They had to go back over it, but these jurors lived it. They spent the last 6 weeks going through it. I think they would have been an even better job, a little bit more of the high points, a little bit more of the presumption. Look, this is what we have. And again, one thing that the government has in this case that was mentioned by Paul and is undeniable, normally you have one case, one burglary case, one rape case, one sexual battery, and you have one witness saying something. When you have two, what we call similar fact evidence, very dangerous. When you have 11, the presumption is guilt, no matter what else comes out in the trial, just because of that many witnesses against you. And I thought that the government might have just spent more time on that, on the obvious nature of the guilt here, and not spent 6 hours. I don't think that they lost them, but I do think that they bored them.
CK, your thoughts? Did the government go too long?
Oh, they went too long, without a question. In closing arguments, it's your chance to summarize the evidence. You go to the salient points. What you want to tell the jury is why they need to vote in your favor. This long diatribe, 6 hours, I can't imagine any case requiring a 6-hour closing. This is a RICO case. So, of course, they've got to connect the dots in a different way, but not in a 6-hour way. What they could have done very effectively is summarize the evidence very quickly. There was so much salient, salacious evidence here. They could have just done that nicely, put it in a bow, and then told the jury, this is why you need to convict R. Kelly of RICO. Boom, 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 boom. This is why he's guilty of this. Bop, 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 bop. And this is why you should never let him walk out this courtroom and be a free man because of boom, 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 boom. And then sit down. You've made your point because, by the way, for 6 weeks you've been laying the evidence. They had compelling evidence, not just from women, but from men. So they really, really lost an opportunity to tie it together and not confuse the jurors. And then tell them, go through any of the jury instructions that they needed to. And then that's it. when you get into all this other stuff, you overly complicate a case. Whether you're the prosecutor in a criminal case or you're the plaintiff in a civil case, your job is to simplify it, to give the jury the reason why, and then to sit down. And the other side's job, the defense's job, is to poke holes in your case. So if you go 6 hours, they're going to be poking forever and ever, and then the jury's going to be confused, and then you've lost that opportunity. So I think they went too far.
All right, Paul, the veteran prosecutor, your thoughts?
It's very similar. I think 6 hours is a very, very, very long time to talk in front of a jury. And I don't think anybody is going to pay attention for that long. It's really difficult in a case like this. Although I will say this closing, I expected to be a little bit longer than most, simply because they were racketeering charges. And for a lay audience that doesn't understand what racketeering may mean, or how it relates to the evidence, that's got to be something you've got to cover to connect the dots as an attorney for a lay audience to understand why the facts and the evidence that was presented is related to a conviction that you want from the jury. The other thing that you really have to focus on in a case like this that makes it a little bit different is that this is a celebrity, and this is someone that people have a familiarity with and almost grant or may grant permission to act differently from what everyone else's standards may be, that they are engaged differently. And so making clear that this went so far beyond the pale, that this was actually not bad behavior, but illegal behavior is what the prosecution had to do. I don't think that that would have taken 6 hours. And just like we were talking about, there were so many salacious nuggets. There were so many consistent facts, so many similar narratives about inappropriate behavior, illegal behavior, videotaping, herpes, underage men, underage women. I mean, putting all of that in a bow, I think could have been done in less than 6 hours. And the concern for me is, if this were one of my lawyers making a presentation like that, what did you talk about for 6 hours? I need to see and know ahead of time before I sign off on a 6 hour closing. What are you talking about? Take this out, take that out, move this to the front. Stay focused and weave a narrative theme along for a jury to take that with them into a jury room, and that shouldn't take 6 hours.
Mark, some have wondered how one person can make up a criminal enterprise, but the prosecution utilized a large blackboard with Kelly in the center, surrounded by a network of associates, the prosecution says enabled Kelly to carry out crimes for 3 decades. The government doesn't have to prove that the enterprise or the actors acted with criminal intent, only that Kelly had the criminal intent. Do you think they've done that?
Again, I really think that they did. I give credit. You know, it's one of those things that you complain too much with a 6 hour closing. It's like you had me until you kept trying to convince me. So I think that was a risk, as Paul was saying. But yes, I thought they did a good job of following the law and making sure a jury who has no idea about RICO, they have no idea about conspiracies, they have no idea about principal behavior and how other people can help you but not be charged with the same offense. But I did think they did a good job of saying, look, this is the guy, it's United States versus this guy. And these other people out there who may have their day in court at some future time, they are not charged because we're just showing you what he did and what these other people allowed him to do. And that's the RICO. That's the organization, if you will. It's the one person that's before you. He's the one on the other side of the V from us. He's the one we have to prove the case against. And we did. And yeah, I do think they did a pretty good job of a relatively complex area of law to try and say to somebody, racketeer, influence, corrupt organization, that guy over there. But I thought they did a good job of it.
All right, stay with us. We've got more with my panel as we continue our coverage of R. Kelly's sex trafficking and racketeering trial.